All right. Welcome back. Welcome back. I've got another fun one for you today. I hope. You know, since I don't read these ahead, I'm just assuming it'll be a fun one, but hopefully it'll be less crazy, less brain hurting than the last episode. Even though it is the same subject matter, we are still trying to catch up on Scofield versus Giard, the TikTok psychic case. And you may remember last time, I'm scrolling through the docket. So last time we were here, we did docket 65 and 66. And those were Ashley Giard's responses to the amended motion for partial summary judgment and her response to the motion for leave to file an amended complaint adding punitive a request for punitive damages. So those were insane. Like, literally, Ashley should be, you know, wearing a fancy white coat in a padded room. Crazy. And it took a lot longer to get through than I had intended because it was insane. It was literally insane. She was making up her own law. She, according to her, until Professor Scofield disproves the allegations, it's a legal fact that Professor Scofield is the murderer. And that's just not how any of this works. Like, it's insane. But she said it over and over and over again in two separate pleadings. And it made my brain hurt. So today we are going through the replies to those responses. So same motions, but these are Professor Scofield, well, her attorneys, their replies saying everything Ashley just said in opposition is complete bullshit, and here's why. So that's what we have for today, basically. So getting into it, yeah. I'm just still psyching myself up for it, even though I know this isn't going to be crazy. It's just a response to crazy. And a response to crazy still means we have to address the craziness. And but we're going to get caught up eventually. So, yeah. So, this first document is the reply in support of plaintiff's amended motion for partial summary judgment. So, this is docket number 66. It's yeah. And I just want to put out a reminder for people. This is going to go out on YouTube early for members. So you'll get this, frankly, once the video finishes processing. I'll try to have it up for the rest of you for, the start of the workday. You know, just as a matter of convenience, so I don't have to load it. I do record them live on YouTube and Twitch, but if I'm not on YouTube live, I don't respond to chat. So just want to put that reminder out there so that people don't, if there are people, they don't feel I'm ignoring them. So I treat this, even though it is live on Twitch and Facebook, I treat it as if it's not live. So defendant Ashley Yard has put forth zero evidence to rebut the facts set forth in plaintiff Rebecca Scofield's amended motion for partial summary judgment. Remember, I called it before I even read the motion. Well, but before I read Ashley's okay, never mind. I'll take that back then, Imuji. I've clearly doing late night. I hit the wrong button. I meant to hit Twitch and Facebook. So never mind. Never mind. That's the problem with doing late night recording sessions, is sometimes you hit the wrong button. Oh well. Oh well. I'm still going to mostly ignore you guys to try and get through this quickly. So yeah. Yeah. And Luna, that was the intention. That was the intention. Way to make me look dumb, calling me out on it. But either way, like I said, I'm going to mostly ignore you guys, try and get through this. But yeah. So getting back to it, in the last video, I mentioned that Ashley wasn't going to bring any facts. And the standard basically for opposing a summary judgment is to say, look, well, in fact, let's go back to it. Let's go back to it. And Rule 56, summary judgment. So a party may move for summary judgment, identifying each claim or defense, or part of each claim and defense on which summary judgment is sought. The court shall grant summary judgment if the movement shows that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as a matter of law. So, like I said, going over Ashley's opposition motion, she would have to show that there is, in fact, a genuine dispute, emphasis on genuine dispute, as to any material fact. And she didn't. I mean, and I predicted it. I predicted that she wouldn't know what was required of her, because she's pro se, she's not a lawyer. She's maybe using ChatGPT, I don't know, but she didn't show any of the facts that were disputed. She just said, well, by law, because Professor Scofield hasn't disproved me, she's presumed guilty. The facts are presumed to be what I say they are. And she hasn't done, she didn't present any disputes as to the actual material facts, no genuine disputes. And so Professor Scofield, first sentence in her reply says it. Defendant Ashley Giard has put forth zero evidence to rebut the facts set forth in Plaintiff Rebecca Scofield's amended motion for partial summary judgment. There's no, and remember, allegations in the pleading aren't evidence. They're not facts. Ashley doesn't have a sworn declaration. Professor Scofield's sworn declaration, according to Ashley, was frivolous. She hasn't, cited to a state, what was it? What was it called in here? Amended statement of undisputed material facts. Ashley didn't state to that. She didn't provide her own statement of undisputed material facts. She just, in the opposition motion, said, but no, this is what I think they are, and therefore that's what it is. The court must take that as true. But that's not the standard. That's not the standard. This isn't a motion to dismiss. This is a motion for summary judgment. And yes, this is the TikTok psychic who accused the professor of doing the University of Idaho murders. And I really, 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 really dislike the defendant in this case, the TikTok psychic. Really dislike her. So, Ms. Giard sets forth no facts contesting that she published statements that Professor Scofield murdered 4 University of Idaho students and that Professor Scofield was having an affair with one of them. In fact, she makes similar and even more inflammatory assertions about Professor Scofield in the opposition to the motion. So you'll notice how they're structuring this. Ms. Giard sets forth no facts contesting that she published these statements. That's element number 1 of defamation. Published statements. These statements are defamatory per se. So that takes care of damages. Ms. Giard puts forth no facts that give rise to any inference that her statements are true. So no facts to assert her affirmative defense. Now, Ashley thinks it's the professor's job in her case in chief to prove that there isn't an affirmative defense, that the burden is on the plaintiff to affirmatively disprove the affirmative defense. No, the burden in an affirmative defense is on the defendant asserting it. So truth as an affirmative defense in a defamation case, it's the burden of the defendant to raise that defense and to show that the defense, in fact, does protect them. That, in this case, the truth. She can't. She hasn't, but she also can't. So Ms. Guillard puts forth no facts that give rise to any inference that her statements are true. They are not. Professor Scofield's undisputed declaration is sufficient to prove the falsity of Ms. Guillard's statements. Summary judgment as to liability is appropriate. And Professor Scofield, like I said, she did a sworn declaration. It's undisputed because Ashley hasn't. She just, in her pleadings, call Professor Scofield's declaration frivolous. It's frivolous, according to Ashley. But once again, I know we went over this in the last video. Supporting factual positions. A party asserting that a fact cannot be or is genuinely disputed. So I don't like the structure of this sentence. So let's break it down into two separate sentences. A party asserting that a fact cannot be genuinely disputed must support the assertion by one of these things. Or alternatively, for Ashley, a party asserting that a fact is genuinely disputed also must support that assertion by citing two particular parts of materials in the record, including depositions, documents, electronically stored information, affidavits or declarations, stipulations, admissions, interrogatory answers, or other materials. And so Ashley says Professor Scofield frivolously relies on declarations and Ashley's admissions. But those are specifically laid out. They are specifically addressed in the rule for summary judgment as precisely the type of evidence that is relied on. But Professor Scofield has frivolously followed the rules. But Ashley, who has not followed the rules, who has not submitted a sworn declaration, we just take her pleadings as true because by law, they are presumed to be true until proved otherwise, which is a false statement of the law. So, argument. The party moving for summary judgment bears the initial burden of showing the absence of any genuine issues of material fact. That's Celotex Corp. Versus Catrett, Supreme Court, 1986. Professor Scofield has met this burden in her amended motion for partial summary judgment. She put forth evidence to prove every element of her defamation claims against Ms. Guillard. Professor Scofield set out facts showing that Ms. Guillard published defamatory statements about her on TikTok. Ms. Guillard repeatedly claimed that Professor Scofield orchestrated the murder of 4 students, and that Professor Scofield had an affair with one of the victims. Professor Scofield set forth facts sufficient to prove Ms. Guillard's statements were defamatory per se. Ms. Guillard's statements unambiguously imputed to Professor Scofield conduct constituting a criminal offense that would be punishable by imprisonment in a state or federal institution. That's Sierke versus Sierke from the Idaho Supreme Court in 2020. They also unambiguously ascribed to her conduct, characteristics, or a condition that would adversely affect her fitness for the proper conduct of her lawful business, trade, or profession. That's from the Restatement Second of Torts, Section 573, or it imputes serious sexual misconduct to another. And that's also the Restatement Section 574. And I'll see Yoakum versus Hartford Fire Insurance Company, Idaho Supreme Court, 1996, which recognized that statements are defamatory per se if they impute to the plaintiff either a criminal offense, a loathsome disease, a matter incompatible with their trade, business, profession, or office, or serious sexual misconduct. And that's citing the Restatement of Torts, once again, sections 570 through 574. Once the moving party has satisfied its burden, the non-moving party must go beyond the pleadings and designate by affidavits, depositions, answers to interrogatories, or admissions on file specific facts showing that there is a genuine issue for trial. That's Celotex, once again, which we cited earlier. So once Professor Scofield has satisfied her burden, the non-moving party, Ashley Giard, must go beyond the pleadings and designate by affidavits, depositions, answers to interrogatories, or admissions specific facts showing a genuine issue for trial. She didn't. She just made up a brand new expanded fan fiction in her opposition pleading and said, "Court, you must take this as true." But it says right here, she must go beyond the pleadings. She's trying to just rely on her pleadings. Her pleadings are factual, therefore, you must accept them as fact. But that's not how it works. That's not how any of this works. It's not how it works. So you've got to go beyond that, beyond the pleadings. Go to actual evidence. Ashley hasn't done that. She hasn't done that. So an issue of fact is genuine if there is sufficient evidence for a reasonable fact finder to find for the non-moving party. A fact is material if it may affect the outcome of the case. And that's Anderson versus Liberty Lobby, Supreme Court, 1986. A party opposed to summary judgment must establish a dispute of material facts using actual evidence. That's Matsushita Electric Industrial Company versus Zenith Radio Corp, Supreme Court, 1986. The opponent must do more than simply show that there is some metaphysical doubt as to the material facts. Oh, I like that. I really like that here. It's almost as if the Supreme Court, all the way back in 1986, were speaking directly to this case. Because Ashley, the court must take my spiritual practices seriously. It's against my First Amendment to call it bullshit to say you need to bring actual evidence. My spiritual practices are actual evidence. The Supreme Court, though, said, hey, you need to show more than some metaphysical doubt as to the material facts. I think tarot cards, at best, could be described as metaphysical doubt. I like that. I really like that citation. It's almost like it was made just for this case. Almost. So, the party opposing the motion may not rest upon the mere allegations or denials of his pleading, but must set forth specific facts showing that there is a genuine issue for trial. So, may not rest upon the mere allegations or denials of their pleading. That's entirely what Ashley's opposition to the motion was. It was just the denials within her pleading. No actual evidence, no specific facts. That was Anderson versus Liberty Lobby. So the mere suggestion that facts are in controversy is not sufficient to defeat summary judgment. That's Thornhill Publishing Company versus GTE Corp., 9th Circuit, 1979. Neither conclusory nor speculative testimony in affidavits and moving papers is sufficient. Instead, the non-moving party must come forward with admissible evidence to satisfy the burden. That's Federal Rule of Civil Procedure 56C. So that's what we were looking at earlier, was C in general, as far as the parts of the record you can cite to. Oops. If the non-moving party fails to produce enough evidence to create a genuine issue of material fact, the moving party wins the motion for summary judgment. That's Nissan Fire and Marine Insurance Company versus Fritz Costs Inc. Costumes. I don't know. 9th Circuit 2000, and this is one of my pet peeves. And in fact, it's something I was listening to a continuing legal education video talking about Blue Booking. The Blue Book is the formatting guide for legal citations. And this CLE was taught by a couple of legal writing professors. And one of the things they said is, there's really only 8, I think, common abbreviations you should be using within your citations. And like insurance company is one. I guess this might just be Fritz Companies Inc. But it really is a pet peeve of mine. Don't abbreviate for the sake of abbreviation. It just causes confusion. And if that is companies, that's fine. But there are a lot of other abbreviations that I've had to guess at in other things. So, and Amy, you're lucky because this wasn't intended to be a live, but I accidentally clicked the wrong button. That's the problem with recording at midnight, but it's also why I'm mostly ignoring the chat, but I'm glad you caught the accidental live. So Ms. Giard has not met her burden. It is undisputed that Ms. Giard has accused Professor Scofield repeatedly and in multiple forums of a quadruple homicide and of having an affair with a student. Under Anderson versus Liberty Lobby, the burden shifts to Ms. Giard. In her opposition, Ms. Giard was required to go beyond the pleadings and designate by affidavits, depositions, answers to interrogatories, or admissions on file. Specific facts showing that there is a genuine issue for trial. That's Celotex. Ms. Giard did not do so. And you'll notice this is all stuff that I mentioned when going through Ashley's motion. Well, her opposition. This is all stuff I mentioned. And it's not that I don't love you guys, parasocially. It's that if I don't do my best to ignore you, you send me off chasing squirrels, and this turns into a 3-hour live that I didn't intend to do. So, yeah. And that's what the intent was. That's what the intent was. Do it live so that it's on Twitch. Not that I get any viewers on Twitch, but yeah. So instead, Ms. Giard simply set out an unsupported narrative, falsely alleging in even more inflammatory detail that Professor Scofield had been having an affair with one of the murdered students and hired another student to kill her and the others to cover it up. Indeed, Ms. Giard added even more unsupported facts alleging activity by the person hired to commit the murders. Her new narrative is not supported by any affidavits, depositions, answers to interrogatories, or admissions on file. It is simply a fantastical story based on a series of false statements by Ms. Giard. Ms. Giard brings forth no facts that show she did not make the defamatory statements, nor does she even argue they are not defamatory. She argues instead that her defamatory statements are true because she received them in a tarot card reading and she believes they are true. While truth is a defense to defamation, Ms. Giard has zero facts to show that her statements are true. Simply believing something is true does not make it so, particularly in the face of actual facts to the contrary. Ms. Giard's assertions in the opposition are unsupported by any affidavit, deposition, answer to interrogatories, or admissions on file. Ms. Giard attaches 8 exhibits to her opposition. Even if the court could properly consider any of them, not a single one establishes a genuine issue of material fact. Not a single part of any of them establishes a fact showing either that Professor Scofield was involved in the murders or that she had an affair with one of the students. Indeed, the only exhibit that bears any relationship to who committed the murders is Exhibit E, the probable cause affidavit that established the basis for arresting Brian Kohberger. But not one word of that affidavit suggests in any way that Professor Scofield was involved. To the contrary, it shows only that there is probable cause that Brian Kohberger alone committed the murders. Ms. Giard argues that Professor Scofield has the burden to prove falsity. That is incorrect. Under Idaho law, truth is an affirmative defense to defamation for which Ms. Giard has the burden, not Professor Scofield. That's Baker versus Burlington Northern, Idaho Supreme Court, 1978. What did I say? What did I say? Truth is a defense. It's an absolute defense to defamation, but it's an affirmative defense, and the defendant asserting it bears that burden, not the plaintiff. So says me, so said me in the previous video, so says the Idaho Supreme Court in Baker versus Burlington Northern. Right there. Right there. Right there. Ashley says, because Professor Scofield hasn't proved a negative, the court must consider my statements to be true. Wrong. Number one, wrong. And Debbie, you're absolutely forgiven for being late to the accidental live stream that wasn't supposed to be a live stream. So that's why I'm ignoring you guys mostly, but yeah. So even if Professor Scofield did have the burden to prove falsity, she has done so here. Professor Scofield stated in her signed declaration that she did not know any of the murdered students, did not have an affair with KG, was not in Moscow when the murders occurred, and was not involved in the murders. Professor Scofield's statements in her sworn declaration are undisputed. They prove that Ms. Giard's defamatory statements are false. Ms. Giard puts forward no facts that in any way refute anything that Professor Scofield stated in her declaration. Finally, in her responses to requests for admission and in her opposition to plaintiff's original motion for summary judgment, Ms. Giard suggested that she would soon obtain facts to support her false statements. She repeatedly pointed out that discovery was not closed and that she had subpoenaed information from the University of Idaho. But now discovery is closed, and it is undisputed that no such facts have been produced. There is simply no evidence that supports Ms. Giard's fantastical story. This court should grant partial summary judgment as to liability on each of Professor Scofield's claims. Dated all the way back in February 16th, 2024, Stoll Reeves, signed Wendy J. Olson and the other attorneys for plaintiff. Funny how we can get through addressing nonsense a lot faster than we can get through nonsense. So next up, we have docket number 68, the reply in support of leave to amend the complaint to add punitive damages. Now, you may remember last video, in her opposition to the request to amend and add punitive damages, most of it seemed like it was Ashley addressing the summary judgment. She was also bouncing around about what the burden was and all that. It's, yeah. So this is Professor Scofield saying, no, really, the court really does need to allow us to amend and add this. So defendant Ashley Giard has no facts to support her extreme and outrageous assertions that plaintiff Rebecca Scofield had an affair with a student and then planned, initiated, ordered, and executed the murder of 4 University of Idaho students. In the face of overwhelming evidence to the contrary, Ms. Giard has continued to make and participate in YouTube videos repeating these false statements. Indeed, she has participated in a YouTube video repeating her false statements at least once more on February 8th, 2024, since Professor Scofield filed her motion for leave to amend her complaint to add punitive damages. See this link to the YouTube video of, the video in question on February 8th. Ms. Giard opposes Professor Scofield's motion for leave to amend her complaint to add punitive damages by ignoring her own ongoing conduct and by using the wrong legal standard. Oh my God, imagine that. Ashley Giard using the wrong legal standard. Color me shocked. Who would have thought? Ms. Giard is undeterred by the facts and by her own failure to produce a single shred of evidence supporting her claims. Ooh. Knives out. They are, the kid gloves are off. Not a single shred of evidence supporting her claims. Not an iota, not a scintilla of evidence. Nothing, zero. Punitive damages are necessary to deter her. This court should grant Professor Scofield's motion and allow her to file an amended complaint to add punitive damages. Argument. To amend a complaint to seek punitive damages, a party must show a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. And that's Idaho Code Section 6-1604, Sub 2. Remember, in her opposition, Ashley kept jumping between Professor Scofield hasn't shown by clear and convincing evidence, and at trial you have to show by a preponderance to win a defamation claim and blah, blah, blah. And she kept jumping back and forth and back and forth and back and forth. And yeah. And CJ5, welcome. Hello. It's an accidental live stream. I clicked the wrong button. So I'm mostly ignoring you guys. But I hope things are great in the upside down. So you'll notice the standard here is reasonable likelihood. So it's not, in order to amend the complaint, to add punitive damages, you have to show a reasonable likelihood that you'll be able to prove the facts to a clear and convincing standard at trial. And the clear and convincing is just the facts to support punitive damages. So to prevail on defamation, it's still preponderance standard, but to get punitive damages, you have to prove the elements necessary for punitive damages to a clear and convincing standard. But to amend the complaint to add punitive damages, you have to show a reasonable likelihood that you will be able to do that at trial. Reasonable likelihood is lower than clear and convincing. It's lower than preponderance. It's, the civil equivalent of, reasonable suspicion. Maybe probable cause. But yeah, so that reasonable likelihood is a lesser showing than a plaintiff must make to recover punitive damages at trial. To recover punitive damages, a plaintiff must show at trial, by clear and convincing evidence, oppressive, fraudulent, malicious, or outrageous conduct by the party against whom the claim for punitive damages is asserted. That's Idaho Code Section 6-1604, sub 1. So, yeah, at trial, you have to show by clear and convincing evidence that that the defamation was through oppressive, fraudulent, malicious, or outrageous conduct. So, in her opposition to Professor Scofield's motion for leave to amend her complaint to seek punitive damages, Ms. Guillard ignores this distinction and gets the standard wrong. Shock. Shock, shock, shock. Getting the standard wrong. Shock. Ms. Guillard argues incorrectly that Professor Scofield must, at this stage, meet the standard for recovering punitive damages. Here, the court must determine only whether Professor Scofield has shown a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. The court shall allow the motion to amend the pleading if, after weighing the evidence presented, the court concludes that the moving party has established at such hearing a reasonable likelihood of proving facts at trial sufficient to support an award of punitive damages. And that's, once again, Section 1604, sub 2. Contrary to Ms. Guillard's argument in her opposition, the question at this stage of the proceedings is not whether a plaintiff will succeed at trial on its punitive damage claim or whether the evidence is uncontroverted. Rather, a claim for punitive damages should be permitted if the plaintiff has shown a reasonable likelihood she could prove by a preponderance of the evidence that the defendant acted oppressively, fraudulently, wantonly, maliciously, or outrageously. That's Vendelin versus Costco, Idaho Supreme Court, 2004. Moreover, since the plaintiff need show only a reasonable likelihood of establishing its entitlement to punitive damages, a court reviews the evidence in the light most favorable to plaintiffs, with the benefit of all legitimate inferences without assessing credibility. And that's Estate of Kane versus Epley's, District of Idaho, 2017. And so that sounds similar to the motion to dismiss standard. It's viewed in the light most favorable, in this case, to the moving party, the plaintiff. In a motion to dismiss, it's viewed in the light most favorable to the non-moving party and accepted as true all legitimate inferences without it. So, like I said, it sounds like basically that. And it kind of, like I said, reasonable likelihood, to me, it sounds like a in a criminal case, the probable cause found in a preliminary hearing, where, depending on where, where the hearing is, depending on the local rules, at a preliminary hearing, the defense doesn't get to put on witnesses. I'm not saying this is the universal rule. This is some jurisdictions. It's just the prosecution puts on witnesses. The defense gets to cross-examine those witnesses, but because the preliminary hearing is just to decide if there's probable cause to go forward, you just need to hear from the witnesses that show probable cause. Those are the prosecution's witnesses. And viewing it in the favorable light, giving I mean, they do assess credibility to a certain extent in a preliminary hearing, but yeah. So, and Kevin, I blame you for this accidental live stream, I think, since you commented on one of the last videos that you wanted a live. So I blame you. Probably. But this was accidental. This was meant to be a recorded video for YouTube, but hit the wrong button because it is late. No, they can't force her to stop. That would be a violation of the First Amendment. That would be prior restraint. But this is a good question. So it would be prior restraint, constitutional violation. The solution, of course, is if she continues defaming people, you sue again. And if she continues stating the same bullshit, you've got collateral estoppel. You go to court and you say, with the judgment in this case, and you say, hey, so this has already been litigated. She is repeating the defamatory statements. I would like to collect more damages, please. Thank you. And the court gets to say, hey, look, we've already got a decision on this. Due to collateral estoppel, Ashley basically doesn't get to say, no, but it's true because the court already decided it wasn't. So the solution isn't to force her to stop. It's to drag her into court again if she doesn't stop on her own. So, unfortunately, that's the way it works. So, to provide some support for her assertion that she did not act wantonly or maliciously, and that she was simply trying to help law enforcement in Idaho solve the murders, Ms. Giard attaches to her opposition a December 10th, 2022 email that she sent to the FBI tip line, and that sets out the same false story upon which Professor Scofield sues for defamation. Exhibit A, in Docket 66, Exhibit A, footnote 1. Ms. Giard did not disclose this email or any other documents during discovery, despite being served with requests for production. She thus should not be allowed to rely on this evidence that she wrongfully withheld. Oh! Oh, oh, oh! Oh! Shades of Baldwin here? You didn't provide this in discovery. We asked for this in discovery. Therefore, the remedy is you don't get to use this as a defense. You don't get to use this as evidence. As far as the court is concerned, this tip to the FBI does not exist because you didn't provide it in discovery. In Baldwin, New Mexico versus Baldwin, the sanction for discovery violations was dismissing the case with prejudice. Here, the sanction for discovery violations is your helpful discovery, your helpful evidence doesn't exist because you didn't provide it in discovery. You ignored their requests for discovery. You ignored, until the court gave you a second chance, you ignored the requests for admissions, which are part of discovery. And then once you finally provided the admissions, you say that Professor Scofield has frivolously used those admissions against you. You frivolously followed the rules. How dare you? Don't you know it's against the rules to follow the rules? Christ on a cracker. She argues that the email shows that she was making a noble effort to assist law enforcement. Notably, the email Ms. Giard argues was her noble effort was sent, number one, well after Ms. Giard had published multiple TikTok videos falsely stating that Professor Scofield had orchestrated the murders and that she did so to cover up an affair she had with one of the victims. And number two, well after Ms. Giard had received 2 cease and desist letters from Professor Scofield's counsel. So it's almost like she sent the noble effort tip to the FBI to cover her ass when she realized she was in deep shit legally. When she realized she was about to be sued, she said, oh, I should legitimize my defamation by sending it to the FBI tip line too. Rather than demonstrating any effort to assist law enforcement by providing a legitimate tip, the email supports Professor Scofield's motion for leave to amend to include punitive damages. It shows that despite being informed on multiple occasions that her statements were false, Ms. Giard persisted in making them. The email corroborates other evidence showing that Ms. Giard committed a bad act and had a sufficiently bad state of mind. And that's Hall versus Farmers Alliance Mutual Insurance Company, Idaho Supreme Court 2008, not 2008, 2008, quoting Myers versus Workman's Auto Insurance Company, Idaho Supreme Court 2004. The email shows that Ms. Giard continued to make statements that were false with an understanding of or disregard for their likely consequences. That's Steiniger Law Offices versus Northern Pacific Insurance Company, Idaho Supreme Court 2008. As Professor Scofield pointed out in her memorandum in support of her motion for leave to amend, Ms. Giard has made even more false statements since Professor Scofield filed her complaint. Ms. Giard has attempted to capitalize on the notoriety of her false claims about Professor Scofield by appearing on YouTube videos repeating her false statements, asserting there is evidence to back them up, and then failing to ever seek in discovery or produce such evidence. That is because no such evidence exists. Moreover, these false statements on YouTube, all of which occurred well after Ms. Giard's email tip to the FBI, also came well after the Moscow Police Department issued a statement that Professor Scofield was not involved. The timing strongly demonstrates Ms. Giard's bad state of mind. It shows that Ms. Giard's ongoing false statements about Professor Scofield were made with malice, oppression, fraud, or gross negligence. And that's Steiniger again. Finally, allowing Professor Scofield to amend her complaint to add punitive damages serves the primary purpose behind an award for punitive damages. It may be the only thing that will deter Ms. Giard from making ongoing false statements about Professor Scofield, where Ms. Giard has no facts to support her statements and where Professor Scofield has demonstrated the statements are false. See Walston versus Monumental Life Insurance Company, Idaho Supreme Court 1996, which says, in general, the primary purpose behind an award for punitive damages is to deter similar conduct from happening again in the future. Nothing else to date has even remotely prompted Ms. Giard to correct her behavior. So basically, Professor Scofield here is saying, look, suing her hasn't gotten her to stop the defamation. In fact, she sees that she's likely on the hook for millions, and she keeps going. The only way to, the only other remedy is punitives and say, you know what? You're on the hook for potential millions in compensatory damages. How about 10 times that in punitive damages? Because compensatory, as the name would suggest, are to compensate for the damages the plaintiff has felt. So it's Professor Scofield showing, hey, I've suffered, $1.8 million in damages. It's defamation. It's hard to determine what the compensatory damages are, but she's tried. She'll try at trial. But punitives are to punish. Punitive. So it's in addition to compensating Professor Scofield for the wrongs done to her, we are punishing Ashley Giard for committing those wrongs. And the way to punish her is to make her pay even more to the professor. So the court should grant Professor Scofield's motion for leave to amend her complaint to add punitive damages. And so I'm reminded, I did get a comment on one of the videos. Well, I say one of the videos, it was the last video on this, because recorded 2 videos back to back, but one of them was Baldwin, and so this wouldn't have been on the Baldwin video, obviously. But let's see. Okay, so Kenny G, probably not the saxophonist, left me a comment on the video and said the referenced abstract for the 5-page Department of Justice article from 1993 says, and this is one of the sources that Ashley cited, saying, hey, the DOJ considers psychics, as reliable witnesses, that psychics help the DOJ solve crimes. And I didn't have the time or the inclination or, frankly, the patience to read that nonsense. But Kenny G did and summarized it for me. So Kenny G says that 5-page DOJ article from 1993 says that the FBI also does not hire psychics and does not plan to use them, although it notes that they, like other citizens, can offer information for assessment by law enforcement officials. Remember what I said about psychics helping the DOJ, the FBI, MK Ultra, what's trying to think of the TV show that it reminded me of. Not the X-Files, but Bill Dauterive. Remember what I said. Psychics are not actually psychic. What they do is they read people, generally. They also cheat. They get biographical information of people that go to their shows, and they use that to cheat. They have an earpiece. Reminds me of that prosperity gospel preacher that basically did that. God's telling me about this person sitting right over here, and they blah blah blah, and it was the preacher's wife backstage speaking into a microphone telling him the person's biographical details, but it was coming straight from God's mouth through and yeah. So generally, though, if they're not cheating like that, what they're doing is, well, they're planting clue. You know, I'm getting a message from someone, whose name starts with K. Oh, that's my husband who just died, Kenny. Yeah, that's who I'm hearing from, Kenny. And he's got a message for you that he loves you. And oh my God, that psychic. But they also read clues. They see a man towing 4 kids to the show, not wearing a wedding ring, and that the they're going to guess, hey, either he's divorced or widowed, and go based on that. So you're not a psychic, you're just reading clues. And so-called psychics tend to be good at that. But that's the same thing law enforcement does. So when the DOJ memo says, hey, just like regular citizens, psychics can help, they can also hurt, but they can help. But we give them the same weight as any other person calling the tip line. And it's just, hey, they might be reading the situation, they're and being outside of law enforcement, they don't have the baggage, they don't have the tunnel vision that law enforcement can create. It's just they're looking at the same evidence, and it's a fresh set of eyes. And that's all it is. That's all it is. But with Ashley going through the University of Idaho webpage and saying, yep, this is the person, she's not basing that on anything. And so, of course, it's wrong. Of course, it's wrong. So, yeah. But that's everything I intended to cover today. So, like I said, we've got few things to go before getting caught up. Had a few more things added to the list that we need to catch up on since I pulled the docket up. But yeah, so as I mentioned, this was an accidental live stream, at least on YouTube. I've been thinking, though, because I do like doing live streams. It's fun. Don't get me wrong. But it is kind of hard to do with reading court documents. Still fun. It's just, yeah. So I've been thinking I need to decide on a day to do a regular scheduled live stream, just of random shit that's happened that week. Have people send me videos, send me articles, send me whatever to discuss on that designated live stream. And part of trying to decide when to do it is, number one, when are other people, that you guys are subscribed to doing it? Not that anyone owns a time slot. It's just, the less competition, the more viewers you get yourself. But also what makes most sense to me. And at the moment, That's probably either Tuesday or Wednesday afternoon into evening for me. But I'm not sure yet. So just throwing that out there as an idea, you know, to basically, if there's a sort of a one-off, absolutely crazy sovereign citizen uh, court filing to go through, but such as the one that is suing Team Skeptic, but will never serve him anyway. So, or like the Brunson brothers here in Utah that have sued every which way they can to try and get the state of Utah to invalidate the presidential election of 2020. So, send me court cases like that, or videos, or news articles, or whatever, and have an evening of it. And so, yeah. But that being said, that's where I'm going to leave you tonight. So do all the YouTubey things, like, share, subscribe, bribe your friends and family to do the same. Thank you to all of you who were in the chat that I was mostly ignoring for joining me, at midnight for an accidental live stream. I realize some people do get viewers, and time zones are a thing, especially in the Upside Down. But yeah, so and yeah, and for the rest of you who were actually sleeping, I enjoy the slightly less insane stuff. And so probably we'll come back next time and do I don't know how much of this we'll get through next time, but so either way, thanks for joining me. I will see you next time, although hopefully I hit the right button next time, so I'll only see you if I intend to see you. And on that note, bye-bye.